A very good evening, gentlemen. I'm sure we all had quite an awesome and lovely day. Alright, you're welcome to tonight's online session. I'm still your host, O.O. Stevens. And tonight we're going to be looking at the topic debentures in corporate law practice. We're going to be looking at debentures in corporate law practice. Debentures are instruments issued to lenders to acknowledge indebtedness by a company. For instance, when a company owes a person or when a company owes another person, such is called a debenture. And also the document that the company and the person that it is owing executes to acknowledge such a loan or such an indebtedness can also be called debentures. And the instrument called debenture is often but not necessarily by deed. So it is often by deed, but it must not necessarily be by deed, meaning it may still not be by deed and it will still in itself be valid. Now, since we have already said that a situation whereby a company is indebted to another person or another company is called debenture, that means that in itself you are going to have an appreciative understanding that where an individual owes an individual, such is not called a debenture. So a debenture is only when a company is involved and such a company is the one that is borrowing. For instance, if a company is lending to an individual, for instance, a bank is a company in the eyes of the law. So if a bank is lending to an individual, you don't call that a debenture. So it can only be a debenture if it is a company that is being lent to. If it's a company that is the borrower, then that is when it can be called a debenture. But where an individual is the one involved, then you can call it mortgage. I am actually saying this so that you will understand that if a company is owing, you don't call it mortgage, you call it debenture. All right, let us look at the types of debentures. We have perpetual debentures, we have convertible debentures, we have secured and naked debentures, we have bearer debentures, and we have registered debenture. And we are going to be looking at them one by one and briefly discuss the principle under each. In perpetual debenture, these are debentures which are made redeemable or irredeemable only on the happening of a contingency, no matter how remote, or on the expiration of a period, however long, or on the happening of an event, no matter how difficult. What this is to its effect is that when this company borrows money from another and the type of debenture that they have agreed to is a perpetual debenture, that means that the company will not repay the loan or will not repay the debt until a particular thing that they have agreed must happens. Or such a company will not repay the loan until a particular time they have agreed reaches. Or such company will not repay the loan until the happening of a contingency. That contingency is no matter how remote, meaning even if it's not likely that such a thing that they have agreed would happen. Contingency means a thing that we don't know when it will happen, but we know it probably may happen. That is contingency. So where we have such an agreement, for instance, I said, or we have an agreement that, okay, this particular loan or this particular debt that we are borrowing now, it is not repayable until after Buhari wins. Now, the issue of Buhari winning, you know very, very well, it's a 50-50 chance, because there is no guarantee that Buhari must win in the next election. That is what we call contingency. So now we may also agree that this particular loan that I am borrowing from you will not be repaid until a particular time has come and expired. So now perpetual debenture is more often than not an exception to the rule in mortgage that says that once a mortgage, always a mortgage, and there shall be no clog on the wheel of redemption. If you listen to my voice note on Mortgages 3 in property law practice, you will appreciate when we said that in a mortgage, there shouldn't be anything contained in the mortgage agreement that will be limiting or restricting the mortgagor from repaying the loan whenever he wants. So what we are now saying now in perpetual debenture now is that this man cannot repay the loan whenever he wants, because we have already agreed that it is only at a particular time that he can repay the loan. That is why perpetual debenture is often an exception to the rule of equity of redemption. Now, if you go to section 171 of CAMA, you are going to see the concept of perpetual debenture. However, in this issue of perpetual debenture, the implication is that the mortgage, that is the company, even if it has finally made the money and it wants to repay the mortgage loan, so long as that particular term that they have agreed has not reached, the person who is lending the money to it, this person is known as debenture holder. The person who has lent the money to the company may choose not to collect the money even if the company has already made it. You know that if it's a debt agreement, assuming you have made the money of the person that lent you money, you can choose to give it to him even before the time that you guys agreed. But if it's a perpetual debenture, no, neither of the parties can unilaterally call such a debenture to an end. And for instance too, if the person that lent the money to the company is finally having an issue, and the person comes to the company and say, please, can you please give me back this money that I lent you, even though the time we agreed has not reached, I am having a very serious problem. The company still reserves the discretion of either accepting to give or not. And if the company didn't accept to give the person back the money, the company will not be doing anything wrong. And also, when the company makes the money and wants to repay, maybe probably the interest they are paying on the loan is so much and they want to repay, and the person who has lent the money refuses and said that you will keep paying me the interest until that particular time we agreed you're going to repay the loan reaches, such a person will not be said to have been doing anything wrong. That is why we say that such is a perpetual debenture. Now, what about convertible debenture? These are debentures which are issued upon the terms that instead of redemption or repayment, they may, at the option of the holders or the company, be converted into shares. Now, there is a difference between being a debenture holder and being a shareholder. If you're a debenture holder, it only means that you lent money to the company. You are not by that status a member of that company. So you are not qualified to even attend the company's meeting because you're a debenture holder. If you go to our topic on meetings, you will see those that are qualified to attend the company's meeting. A debenture holder is not qualified to attend the company's meeting because he's not a member. But assuming the type of debenture that they have entered into is a convertible debenture, meaning that this debenture holder will be telling the company, or the company will be telling the debenture holder, okay, instead of us to give you this money back, why not now use it and convert into shares? Because you only become a member when you have shares in a company. So why not use it and convert into shares? And by virtue of so doing, you will now become a member of the company. So if there is an agreement to that effect between the debenture holder and the company in their debenture agreement, then such can actually be called a convertible debenture, meaning that the debenture holder will, by virtue of that type of debenture, become a member of the company. You can see this in section 172 of CAMA. Now we have bearer debenture. These are types of debentures payable to anyone who is holding the debenture. For instance, now the issue of check. You know that if somebody gives you check now to go and withdraw, it is you that is presenting the check to the bank. It's not necessarily you that owns the account. A person who owns the account can still come and present check and also withdraw from his account. Then that same person can still give check to another person and the person will come and withdraw. So what we're talking about now is that the bank may choose to pay, the bank may choose to pay the money to the person who is holding the check. That's called bearer. So now, when we now link it now to the concept of debenture, that means that the loan is repayable to only the person who is holding that debenture agreement in his hands. So probably the debenture holder might have given the debenture agreement to maybe his cousin or his son to take it to this company to use it to collect the loan from the company. So the company will be paying the person who is holding that debenture. But it has to be agreed that this is a bearer debenture, meaning it is payable to only the person who is holding or who is bearing that particular debenture agreement. And we now have registered debenture. Registered debenture is just like a sharp contrast of bearer debenture. In registered debenture, it is only the person who has entered into that transaction with the company that will be repaid that loan. So it's only that person that will come for the loan. So meaning it's only the person whose name is registered on that particular debenture deed that will come for the loan to be repaid. If not, such may not be repayable. So if the type of debenture they are entering into is a registered debenture, this is the implication. Now we have secured and naked debenture. Secured and naked debenture. I hope you know very well that anybody who is lending money and anybody who is borrowing money, the lender most often than not will normally require for what is called collateral. Now in property law, that collateral, we call it charge. In property law, that collateral, we call it charge. Charge is not necessarily a property in quotes, but charge is like an encumbrance placed on a property. Charge is like an encumbrance placed on a property, meaning that this property is a no-go area because it is a subject matter of a loan. So when a person uses a collateral, or sorry, when a company uses a collateral to borrow money from the debenture holder, such is known as secured debenture, because we will say that the debenture is secured by a charge, meaning that there was a collateral. But if it's a type that there was no collateral that is used to actually secure it, then such is called naked debenture. Such is called naked debenture. So you need to appreciate that the concept of your legal and equitable mortgage is also obtained here somehow. So naked debenture is just a type of loan that is payable whenever, if able. So I will pay it whenever I can and if I can. So that is the concept of naked debenture. So there is no charge, there is no collateral, there is no property that you gave to me before I gave you this particular loan as a company. Such is known as naked debenture. So when we say that it's a type of debenture that is not secured with a charge, it's called naked debenture. But a type secured by a charge is known as secured debenture. You can see this in section 173 of CAMA. And in charges are further subdivided into two. We have what we call fixed charge, and we have another that we call floating charge. What is a fixed charge and what is a floating charge? When we talk about fixed charge is usually created over movable property and properties that are over immovable properties, or properties that are identifiable. Properties that are immovable, like land, like house, that is known as fixed charge, meaning the property is fixed in a particular place. Now, the reason for a fixed charge is that this thing that we are using this thing that you are now using as a company to come and borrow this money from me, is there any place that if we go to now, we are going to see it? That is called fixed charge. And now, one thing about fixed charge now is that the company cannot use that property the way they like again. So when a charge is fixed, that means that particular property is not going to be used by the company pending when they repay the loan. For instance, if a company uses its undeveloped land that is situated at a particular place to borrow money from the debenture holder, if it's a fixed charge is to the effect that the company is not going to use that particular property until they pay the loan. This is because they wouldn't want the value of that property to either reduce or something like that. But when we talk about floating charge has the effect that even if the property is ascertainable, the company can be using it. Also, floating charge can also be used even if it's not yet in existence. What are we talking about here? For instance, I can come to borrow money now from a bank. I can come as a company now to borrow money from a bank to use and maybe have a plantation, or to use and have a farm. Now I can use the crops in that farm as collateral. You know that the crops are not yet in existence as we are talking now. But I can choose to, we agree that when I finally plant these crops and they grow, those crops will become the collateral. So the crops are not yet in existence, but we can choose to agree that even when it comes into existence, it will become the collateral. Or we can even agree that I can be making use of the property. For instance, now somebody can use his car stand where he's selling cars as a collateral. He will use the cars there as collateral. Now, those cars that he is using as collateral, if it is a floating charge, he can still be selling the cars. So probably when we had the agreement, you had 100 cars here. Nothing stops you if it's a floating charge to be selling the cars. But you need to make sure that as you're selling the cars, you are reinvesting the money into buying other cars, so that there will be cars there. And anytime I'm passing, as the person that lent you money, I will be seeing cars. So that is one thing about floating charge. Floating charge, you are allowed because of business and the economic convenience. You can be making use of the stuff, but there has to be an undertaking that you would make sure that you are not using that particular property, or you are not doing that particular thing in a manner that is adverse, or that is contrary, or that would affect the debenture arrangement between you and the debenture holder. And in a situation whereby you now decide to use the property in a manner that is contrary to what you have agreed with the debenture holder, why we call it a floating charge is because it is just like an imaginary airplane that is hovering over the properties of the company. So maybe when I now notice now that particular car stand that we agreed that is going to be the collateral, you have sold all the cars there. I'm not even seeing any single car there. But since it's a floating charge now, that particular charge that is floating can now come and land on any property of the company. So even despite we had an agreement that it is going to be the car stand that will be the collateral, but you have used the car stand, but you have sold the cars and you have not replaced any. That means that you have used in a manner that is contrary. I can come now and attach even if it's your land. I can come and attach even if it's your house. That is the implication. And when such happens, it is called crystallization. When such happens, it is called crystallization. So crystallization happens whenever the company uses the charge or uses the property in a manner that is inconsistent with the agreement that has been had with the debenture holder, and now the floating charge will now come, or the floating charge, let's just take it that the debenture holder will now come and attach any property of the company, despite it may not be that particular property that was earlier agreed on. So we now say that the charge that is floating has now landed. It's just like an airplane that is flying. It has now landed, and any property of the company that it lands on, it is going to convert it to a fixed charge. And once you convert it to a fixed charge, I mean that the company is not going to use it. That is the implication, and we call that particular type of process crystallization. And we call that particular type of process crystallization. Now, let us look at the procedure of creating a charge. Let us look at the procedure of creating a charge. Now, first of all, there will be a board meeting that will be convened by the company. After that, they will now prepare and execute and stamp the following documents. Now, they will stamp the documents, they will obtain governor's consent, and they will register it at the land register. That is where land is involved. So what is obtained here now is that the board of directors will have a meeting, and they will now resolve to maybe engage in the process of borrowing money from another, which is called a debenture holder, for the purpose of the discourse. Now, once that happens now, then when they have an agreement with the debenture holder, they are definitely going to prepare a document to that effect. And when that document has been prepared, then the document will be taken to the Federal Inland Revenue Service. Then it will be stamped there. When it is now stamped, assuming it involves land, then it will be registered in the land registry. So after that, that particular charge will also be registered at the CAC. It will register at the CAC. Then you enter the particulars of the charge in the register of charges and now obtain a certificate of charge from the CAC. These are the procedures. Let me take it again. There will be a board meeting that will be convened. There will be a preparation of the document, that is preparation of the charge document, that of the loan document. Now there will be stamping of that document. There will be an obtaining of governor's consent, and there will be a registration of the land registry. That is where the collateral is a land. And after that, you will also have to register that particular charge at the at the CAC. After this at the CAC, now you will now enter it in the register of charges. Register of charges is one of the registers that must be kept by a company, so showing that this particular property of theirs are encumbered. Then after that, CAC will now issue what is known as certificate of charge. Now, what is the implication of registering a charge? Typically, a company that enters into any type of debenture is expected to register the charge at the CAC within 90 days. This is an MCQ area. Within 90 days, a charge is expected to be registered. Now, where you fail to register a charge as requires, it will not render it void, but it's going to render it void against the liquidator, because you, who is the debenture holder, will no longer become a secured debenture, or you no longer be called a secured creditor. The implication of this now is, assuming a company is about to wind up, there is always somebody appointed which is called a liquidator. So that liquidator is not bound to pay you first. That is the implication. So the liquidator is not bound to pay you first. This is because you didn't register your charge. So this is by virtue of that now seen by in the eyes of the law as a naked type of debenture, because that's why you secured it with a charge. You ought to have registered it at the CAC so that CAC will really know when a liquidator has been appointed to liquidate or wind up the company. Then you will now be among the people that will be given priority in repaying their loan. Remember that if a company is winding up, the liquidator must make sure that every debt or some or most of the debt that the company is owing are repaid. But where you didn't show anything to show that, okay, this company is owing me, this is our agreement, and this is their property that I'm holding. So if there is no property of the company that you are holding or that has been registered as being encumbered, then it is going to probably be one of the things that the liquidator is going to sell to repay the debt of the company. And if the liquidator does not repay the debt of the company, and since there is no place that you have registered your charge, the implication of that is going to be that it will be rendered void against the liquidator. But one thing you need to note is that it does not discharge the obligation for that debt to be repaid. It does not discharge the obligation for that debt to be repaid. What this means is that the debt will still be considered repayable, but it is only going to be repaid after other creditors have been paid. After other creditors have been paid, then it is going to be repaid. So just don't think that because a charge is not registered, that means that this young man is not going to be repaid. No. The only thing is just that it changes the preference or the priority of repayment. It changes the priority of repayment. So this man is not going to be paid first because he's not giving priority any longer. But that is not to say that that debt will not be repayable, because the law still consider it as a debt, and every debt is expected to be paid. So just note that the implication of not registering a charge is to the effect that any person who did not register his charge, then such will be void against the liquidator. And I have told you that what it means is that the liquidator will not give you priority in the course of repaying the debtors of the company. However, the debt will not go down the drain. It will still be repaid, but after people that have been given or people that have secured their own loan with the company and such a charge is registered after they have first been considered and all that. Now, does a debenture holder have a remedy? Does a debenture holder have a remedy? Yes, in a situation whereby a company refuses to pay a debenture holder his money, then he can take out some remedies. We also treated this in the rights of a mortgagee in our property law practice in Mortgages 3. We also treated it. So we're also treating the rights or the remedies that are available to a debenture holder in a situation whereby he did not get his loan repaid by the company as at when they agreed. Now, one of the remedies is that he will apply for recovery of his principal and interest. He can apply to court for the company to be compelled to pay him his money and also every interest that is accruable on it. He can also apply for a petition for winding up. Remember, when a company is unable to pay its debt, and that debt is from 2,000 naira and above, and a company cannot be able to pay such a debt, then it can be a ground to apply for winding up of such a company. So the debenture holder can actually apply for winding up of such a company. The debenture holder can also apply for sale of such a company. He can also apply for an order of sale. And remember, if you listen to my voice notes on Mortgages 3, you will appreciate the concept of what sale is all about. When the company is sold, you are expected not to be the agent of the company with respect to the process of the sale, but you must be the agent of the company with respect to the proceed of the sale. What this means is that you are not expected to definitely sell the company and its assets at a price that is commensurate with its worth. So meaning that the company probably may worth 100 million, you may sell it 70 million. But however, when you finally sell that company at that rate, and probably what the company is owing you is 40 million naira, you are required to return the balance or the surplus or the excess of it. So if you sold it 70 million, you will take your 40 million naira and balance the company the remaining excess. That is what we mean by you are the agent of the company with respect to the proceed of the sale, but not its agent with respect to the process of the sale. All right, there is also another type of remedy which is called foreclosure order of foreclosure. What this entails is that if the court gives this type of order, the company has no business again with that particular property. So foreclosure order means that the company has been told bye-bye to the property. So even if the company is owing you 40 million and you sold the company at the rate of 70 million, the company has no business with it again. And also, if the company is owing you 70 million and you sold the company at 10 million, you cannot come back to the company again requesting them to give you balance. Unlike in the unlike in the order of sale. If in the order of sale you finally sold the company or sold the property of the company at a rate that is lower than that which they are owing you, you can still apply for an action to recover the balance sum if it's order of sale. But if it's order of foreclosure, if you sold it at a rate that is lower than that which the company is owing you, you cannot come back to the company again expecting or requiring them to pay you the balance sum. That is the implication of both foreclosure and the order of sale. Remember I said that order of sale, order of foreclosure, the company is foreclosed. Foreclosed means we don't have any business with you again. So even if we sell this thing at the rate of 100 naira, despite you're owing us 10 naira, it is our gain, and we are not going to account to you for any surplus or excess that is atop the money that you have given to us. Now, what if a company finally repays its loan that it is owing a debenture holder? They are expected to file what is known as memorandum of satisfaction at the CAC. The reason for this is because as they have registered that particular charge, it will be shown in the record of the CAC that this property of the company is encumbered. And if it's encumbered, meaning that the company is in debt. So it will be required or advised the way you file your deed of discharge or deed of surrender in mortgage. That is also how you file what is called memorandum of satisfaction in debenture. So when a loan has been repaid by a company, they will file memorandum of satisfaction at the CAC, and the reason is to remove every type of encumbrance that has thus been placed on that particular company's property. And this memorandum of satisfaction is always in Form CAC 6.2. It's in Form CAC 6.2. You can see section 204 of CAMA. On that, we are going to be drawing the curtain on the topic debentures. And remember, we have associatively discussed this in line with law school expectations and law school outcomes. And if there is any question that is going to flow from this particular topic, it will, by the grace of God, not be outside the purview of what has thus been discussed. However, you are not advised to de-emphasize the need of also reading associatively. Thank you so much, and until we meet again, do take good care of yourselves and blissful night rest.